I'm not on LinkedIn. It doesn't allow me to go live on LinkedIn.
Yeah, it shows us we're
Hey,
live there.
we are live now. Good morning, everybody. And my name is DV Dronam Raju. I am the CEO and founder of InfoSec Enforcer. And we have Brad Hammer. Hi, Brad.
Hi, I'm Brad Hammer. I'm data privacy lawyer, founder of Vicaris Group, working on data privacy, cybersecurity, compliance matters.
And here we are today to discuss about the first CCPA lawsuit settlement, which is Hanna Andersson and Salesforce.com data breach lawsuit settlement, right?
Yep. So they combined a number of lawsuits into this particular settlement. So none of them are carrying the titles that they were originally filed under. So
exactly. And so let's talk about it. What are the facts of the settlement, Brad? Why was the lawsuit brought about, and what was it regarding?
Yeah, so there was a data breach of Hanna Andersson's data within the Salesforce cloud, right? And it impacted approximately 200,000 individuals whose data was in there, and it included their payment information in that. So Hanna Andersson, being a retailer that was using Salesforce.com as their data warehouse or data storage place, and they're storing credit cards and processing information and that kind of thing in there. So yeah, it stemmed from that over a set window of a couple weeks, I think, where there was data being exfiltrated, and it impacted approximately 200,000 people. Lawsuit filed in California under a number of different theories, including sort of broad negligence, in addition to California specific claims with regard to CCPA, which is part of the reason we're talking about this now. It was one of the first cases to sort of bring in CCPA as a part of this, because of the really specific damages and private right of action CCPA allows. In addition to that, there was a claim under Virginia law, I believe, for insufficient notice. But that brought us to where we are in terms of getting the class together and looking at the settlement. So
yeah, and it appears that as far as California residents are concerned, only about 10,000 people are impacted under this. And I believe the Attorney General got notification of that as well. So there seemed to be some distinct difference in how the notifications were done. So the incident response itself seemed to be of issue, where the initial notification that went to all the consumers, the customers of Hanna Andersson, said something, while the notice that was sent to the AG said something slightly different. Whatever that like one of the differences there was, I think the AG got notification that maybe the data was available for sale on the dark web. That extra language that was in there, right, was also a cause.
Consistency, and we talked about this frequently. Part of your incident response plan needs to be consistency of messaging, and making sure you fully grasp what has happened before you send your notices, or at the very least, if you send an initial notice and something changes between the time that you send that notice and say you send a notice to the Attorney General, then you should be updating individuals about what actually happened. So in this case specifically, the difference between, like you said, whether or not mentioning data was available on the dark web really increases the risk to an individual in terms of how they might respond if that information is provided or not provided. And so then in theory could increase the amount that they're eligible for, or the amount they might sue for, because of the risk to them as an individual. So
right, there's also a difference that I think you discussed before. The breach actually happened in September 2019 through November 2019, almost about 6-7 weeks where it happened. But CCPA was effective only 1st of January.
Mm-hmm.
But the filing and the notification was sent out in January.
Yep.
Maybe that was a cause.
Yep.
Um, why do you think the plaintiff settled? I mean, let me talk about why the plaintiff settled, and then we can talk
Yeah.
about why
Yeah.
Hannah and Salesforce settled.
Yeah. It's interesting because um, I- I'm not. I'm not sure how if it had the court certainly did not dismiss the CCPA claims as being out of hand or something like that in terms of timing, and so those claims were still valid at the time, but it shows a deliberate when the lawsuit was filed, it shows a deliberate choice on behalf of those lawyers that I think you're going to see more often. Because if you look at where the terms and conditions, the Hanna Andersson terms and conditions would say the venue should have been, right? So where the lawsuit should have been filed, it's Oregon, right? But Oregon doesn't have CCPA to give you sort of that additional cushion of or additional claims.
Right,
Whereas
right.
because they were impacted California individuals, the lawyers, the plaintiffs' lawyers in this case, made a very distinctive choice to file this in California, so that those claims could be included. Because if the venue is moved, I don't know those claims would have been upheld, right? And so in this case, if the lawsuit had continued, it may have been eventually moved to Oregon, but I think that it's worth noting that I think this you'll see this going forward now that CCPA is the case. If there are California residents impacted, they are going to file in California regardless of where the venue is going to be, because let the defense attorneys make the argument that venue should be somewhere else and see what we can get in terms of settlement before then. So
Exactly,
yeah,
exactly. And also, if the venue had shifted to Oregon, even the Virginia privacy
yeah,
breach notification stuff also will go away, vanish
yep,
almost.
yep,
So a number of reasons why it was easier to keep it in California and go
yeah,
after.
yes,
So the initial ask from the plaintiff was almost $5 million, and now they
hmm,
said 400,000.
yep.
I mean, doesn't that seem as if they had no claim? Uh,
Yeah, it's interesting because these settlements, so these lawsuits are very rarely making their way to an actual jury to decide a dollar amount, and so it's really difficult to say whether this is a good or a bad outcome. If you actually compare it to other larger lawsuits, like say the Target breach or the Home Depot breach, which averaged a dollar, or I think less than a dollar per individual impacted. In this case, we're actually averaging $2 per individual impacted, about $200,000, or about 200,000 individuals, $400,000 settlement. So this, as a whole, that sounds like not very much money, right? But it's in reality, as far as these settlements go, it's technically a higher number than what these typically average. That being said, a $200,000 or 200,000 individual breach compared to a 10 million or 20 million individual breach is actually a relatively small breach in that sense. So yeah, I don't think I think that this is actually uh, the plaintiffs came out pretty good, or with a
right.
pretty good number in this case, all told. And I don't know if CCPA had an impact on that, but it certainly they certainly, one, the plaintiffs didn't want to explore having to move their case to Oregon, and two, the going before a jury just isn't something that is well tested in this case, because almost all of these are settling. So, but as far as
Right,
settlements go, this is actually a pretty good number in terms of impacted individuals. So
right. And so, what would each of the class plaintiffs get in this? I mean,
yep.
obviously not a dollar or under a dollar,
Right.
because if you take out the attorney fees out of that, it will be less than a dollar,
Yep.
or maybe a little over a dollar. I don't know.
Yeah.
Uh,
So there's the $400,000 pool of money, and individuals can put in a claim for $500 up to $5,000, depending on how severe their impact was to them. And actually, if depending, and that number will be reduced if, say, there are too many claims, and that it goes beyond that $400,000. So then, in theory, those individual numbers will be reduced. On the flip side of that, it actually says if that entirety of that $400,000 is not claimed, individual amounts could go up to $1,000 and $10,000 per individual, depending on size of claim, in order to essentially use up all of that $400,000. So on an individual basis, if you think you might be impacted by this, it's worth submitting a claim, because it's the numbers for impacted individuals are pretty good, but you have to actually submit the claim. That's why it's not as if everybody's getting sent $2.
Right.
It is, and part of that is too, because if there is a large subset of those individuals that were not impacted in any way, shape, or form, arguably it's reserving an amount of money for individuals that did suffer some negative economic consequence, right? And that's part of the reason why there's that $500,000 to $5,000 number, because if you can demonstrate that you actually had a monetary loss as a result of this, then that money is really designed to make you whole again. Like that's the point of this lawsuit, not just to sort of scatter free money to individuals. So
right. Yeah. And what are the other things that the settlement imposed on Hanna or Salesforce as such with respect to their business practice changes? I think that's also a really big one. Right.
Yeah, so, it's interesting, and the focus on the business practice changes really, I think, are more on Hanna than Salesforce, and I think that speaks to sort of where the source of the breach was here, but it's sort of conducting risk assessments and actually measuring their security measures against some standard. They mentioned the NIST standard specifically in here.
Right.
Multi-factor authentication on cloud service accounts. Alerting.
Which Salesforce does provide the facility to do that. Maybe Hanna did not,
utilize. I think
facility, right.
And I think that's one part of why the focus here is on Hanna, because I think Salesforce arguably had the tools available for them to use. It's just they weren't using those, right? And specifically, there's multiple mentions here in the business practice changes. Hire additional technical personnel, hire a director of cybersecurity. And so there certainly seems to be some recognition by the court here that not only was Hanna not implementing the appropriate security procedures with regard to this, but that may have been a direct result of not having engaged the right professionals to do so, right? And so whether that's internal or external professionals, but is there somebody looking at your privacy and security practices to ensure you're doing it right? And there's a clear message from the court here that wasn't the case, I think. So
yeah, I think some of these things are typically what you would typically do, like conducting pen testing in the environment and the user base, and doing some level of anti-malware, antivirus type of applications in the environment, stuff like that. Review of audit logs. These are typical business practices that any company would do. I guess Hanna was missing many such practices.
Right. It makes me wonder what was produced that would give some indication that those weren't there, or the degree to which maybe they had them and weren't doing them, or they're just stressing that these things should be a focus for Hanna. But yeah, it's the degree to which there was at least enough of an indication that these things weren't happening that it was worth including as business practice changes. It shows me that there was something going on there. So
right. So what do you think would be Salesforce's portion of the settlement? Is it likely that Salesforce actually did some Salesforce and Hanna had some conversations in the back to indicate that Salesforce would be covering some of these expenses? Or do you think Salesforce basically said, none of this is our problem, it's all your problem? Why are we even mentioned in the class action?
Right.
What would have been Salesforce's response?
They're mentioned in the class action because the plaintiffs need as many pockets as they possibly can to try to get some money out of, right? So, and Salesforce, I don't know the difference of annual revenue of Salesforce and Hanna Andersson, but I would guess Salesforce is a deeper pocket, or at least an additional pocket, right? And so, if having reviewed Salesforce's terms and conditions on behalf of other clients previously, I am actually pretty sure that their terms are pretty buttoned up in terms of, unless there actually was something that they did wrong. If it was really a misuse by Hanna Andersson, my guess is that Hanna Andersson is going to be footing most of the bill here. But that would be subsequent litigation between the two of them if they wanted to pursue that. But and at that point for Hanna Andersson, it's going to be what is this $400,000 versus how much more would we have to pay more lawyers to try to get some money out of Salesforce.
Exactly.
And so yeah, if I had to guess, that's the way that's going to play out.
I think, in my opinion, I think the plaintiff lawyers recognize that Salesforce has the practices which resulted in it, and recognize that it is easy to settle with a smaller company.
Right.
It's going to be tough to go after Salesforce missing out a few pieces in their best practices or practices. The biggest piece that I see here is the hiring of a cybersecurity, like a CISO kind of a person. And that comes with a lot of responsibilities to do certain sanity checks and implement certain best practices with respect to e-commerce platforms, right? I think that was the biggest piece that I feel is the cause of all of this. Right?
It's telling to me that you mentioned a lot of those things that they are required to do, audit logs, et cetera, and those are fairly standard things to suggest. It's telling to me that they actually specifically called out that there was a specific individual that needed to be hire a director of cybersecurity, that they didn't have, the implication being that they didn't already have somebody that was responsible for cybersecurity, which is, it happened, any size company there, depending on how staffing is worked out, maybe they didn't. And that could be, but it certainly puts them in, Salesforce has someone in charge of cybersecurity, likely multiple or a whole team of people in charge of cybersecurity. And so the degree to which you can't point at Salesforce and say, oh, you don't have a CISO that caused this, in the degree to which Hanna Andersson does. And to be perfectly honest, you look at the settlement and the direction in the settlement, and if Hanna tried to turn around and get money out of Salesforce, they would have to come up with a pretty, sort of smoking gun of this was your fault, Salesforce, and not our misuse of your platform, right?
Yeah, and so I think the plaintiff attorneys made out pretty well on this one, though. 120 grand going to them, about 30% of this stuff.
And that's why there will always be these types of lawsuits, and why they will be likely filed in California. And with CCPA, we will see more and more of them, and specifically more and more of them, coming out of California. It's not, that's not my personal business in terms of I work on behalf of businesses typically, so I help with compliance. I don't file lawsuits, but there's a reason that those law firms exist. It's because they are a part of this consumer protection regulation, that when there's a private right of action that exists within the law, and there's potential class actions to be filed, there are law firms out there that will file them, because especially in this space where settlements are very common, because where settlements are very common, they don't have to put in the work to go to trial and all that trial prep that is arguably a ton more work to do. Where settlements are common, class action plaintiffs lawyers will be there. So
right, and here the main plaintiffs got the highest award, I believe, right? So about $5,000 each, or some combined of 5,000 somewhere. So the main plaintiffs got the highest award on that, and I think if lesser number of plaintiffs come and claim, then pro rata, all plaintiffs will get the remaining money. So there is still, for the main plaintiffs, it's worth.
There's incentive to be there, right? Because and not to be jaded about it, but the attorneys would say to them, you're an impacted part of this class. If you would be the representative for this class, we're going to basically do the work and get things filed, and then
Right.
if it settles, we'll take our cut. Otherwise, it doesn't cost those class representatives anything to be involved, because the plaintiff's attorneys work on a contingency, and so for in their perspective, it's just sort of a bonus $5,000. That's not to say I don't know the specifics of those individuals, and they may have suffered some damages as a result of this. And I certainly don't discount the fact that there are people that are, sometimes greatly impacted by these breaches and are certainly entitled to damages. But it's variable in terms of what those impacts are. And if one of the things to stress is the better your notification processes are, the more proactive you are, and the more you can mitigate risk associated with a breach, because breaches happen to everybody, no matter
Right.
how good your security is. And the more you can do to mitigate the risk to the individual, which is really the key here, the better that you're going to come out of this. And the better that your customers will come out of this too, right? This is an incentive to be good on customer services, like have good, robust security. If you have a breach, have the data impact be minimal. Make it so that if you have a breach, those individuals don't suffer a large impact, and you can address that with them and make sure that they are protected if there is an incident. So,
Right. Right. So, what do you think? I think there are several other CCPA-oriented lawsuits,
yep,
mostly the Zoom lawsuit coming up
yep,
as well, which is also I think they'll also likely settle.
yep,
Uh, Most likely, they're not going to jury awards. That's going to
yep,
be tough
yep,
with some of these things, and it's likely
yep,
going to be do A, do B, do best practices, and all kinds of other stuff associated with it for now.
yep.
Uh,
And we, you and I have talked about this before. That really, if you are the key takeaway here for any business that is not currently subject to a lawsuit is the better your story is and the better your response is, the more likely you are to come out with either a low settlement or resolve this in some other way, right?
right.
Because there are lawyers out there that are motivated to file these lawsuits. At some point, you can't get around that. But if you have good security measures, if you have the right staff, if you've engaged the right professionals, third parties, in that, when you have a good story to present to those plaintiffs' lawyers to say, look, we did all this and it still happened, but then when it happened, all of this happened, and so we actually prevented a lot of damage. So this is the more robust your security procedures are, that you can have a good story if something does happen. I mean, that's how you really make these settlement numbers low and hopefully mitigate some. You could mitigate litigation entirely, right? It has to, there's a question of if it's worth the plaintiff's attorney's time, if
Correct.
depending on how severe the incident was or not severe the incident was. So,
Yeah, I also think that the next big one is going to be, I believe, Rahman versus Marriott was filed
mm,
in April.
yep,
That's going to be the big one. If this is
yep,
any indication, the Marriott
yep,
one is going to be substantially larger in
yes,
terms of settlement amount. So now the bar has been set. It has to be at least $2 per
right. And
impact individual across,
it'll
right?
be interesting to see as CCPA becomes a part of this. Do those numbers start going up because of that? That private right of action and that guaranteed
Correct.
money for
Correct.
California individuals. Are they bumping the numbers up in order to compensate for that? We
Yeah.
can't tell after just one, but we'll see if this becomes a pattern.
So the only thing we can talk about as part of how to prevent these is to have better practices.
Yep,
Just go through, make sure you have good security or implement best practices, do some risk assessments and stuff like that. And if you can actually say, we did this, we did this, we did this, and despite that it happened,
yep,
you're likely to go to settlement versus go to
yep.
jury efforts.
Yes,
I
yeah.
mean,
Just pay close attention. Do the work that you do need to do on doing the work on the privacy and the security front before an incident happens. It's like insurance, right? It's sometimes
right,
you have to hold your nose a little bit. It's hard to get the C-suite to pay for it, but on the back end, it will really be beneficial if and when something happens. So,
right, right.
yep,
And more of these are going to be on their way.
yep,
There is no doubt
certainly
about
are,
it.
certainly
Um,
are. So.
Cool.
All
Thank
right,
you,
great.
Brad. Thank you
Thanks,
for
CV.
enlightening us. And, hopefully we'll do another one of these in a couple of days.
Sounds great. Thanks.
Thanks.